Hello everyone. Today we will be talking about Hindu women's rights under the Hindu Succession Act. The Hindu joint family consists of all the persons who lineally descend from a common ancestor and includes their wives and unmarried daughters. On the other hand, the Hindu co-parsonary is a narrow body and includes only the persons who acquire by birth an interest in the co-parsonary property. The co-parsonary is composed of the last holder and his three lineal male descendants. Under the Mitakshar law, property inherited by a Hindu from his father, father's father or father's father's father was considered to be ancestral property or unobstructed heritage as regards his male issues. A property which was inherited by the Hindu from other relations was considered to be his separate property. The modes of devolution of the property under the Mitakshar school and the Dayabhag school differed on the basis of the type of property. For instance, the joint family property went by survivorship and the separate property went by succession under the Mitakshar law. Under the Dayabhag law, the properties went by succession. The women's property can be classified into two parts. There were two types of property which a woman could hold. The first was Stridhan and the second was the woman's estate. Stridhan can be described as a property which was given to a woman at the time of her marriage as a gift. Stridhan was considered to be the woman's absolute property and she enjoyed full powers to alienate, sell, gift, mortgage, lease or exchange all of these properties during her maidenhood or widowhood. But there were certain restrictions if she was married. On her death, all types of Stridhan passed on to her own heirs. The second type of property, that is the woman's estate, was held by the Hindu female owner with limited powers of disposal. She could not ordinarily alienate the corpus of the woman's estate except for legal necessity, for benefit of the estate and for religious duties. On her death, the woman's estate devolved upon the heir of the last full owner known as the reversioners. When we look at the pre-independence laws, we find that the Hindu Law of Inheritance Act of 1929 conferred the right of inheritance on three heirs. These were the son's daughter, the daughter's daughter, and the sister. The Hindu Women's Right to Property Act of 1937 was the other act which came in pre-independent India. The widow of the deceased would take the same interest which her deceased husband had in the joint family property, but as a limited owner. After the independence of India, we find that the Constitution of India in its Part 3 and Part 4 gave importance to social and economic justice. The Hindu Succession Act, which came in 1956, devolved right of inheritance and full ownership on Hindu women. Under the Hindu Succession Act, it was made applicable to all the Hindus, including Buddhists, Jains, Sikhs, and it laid down a uniform and comprehensive system of inheritance. It applied to all the people who were governed by Mitakshar and Dayabhag schools as well as other schools. It was in consonance with the needs of a changing society and an improvement over the old Hindu textual law, especially the law relating to succession amongst the Hindus. For example, the non-inclusion of female relatives to inherit the property, and it gave preference to the male heirs. It removed the existing inequality between male and females, and it gave respect to the right to property in the joint family, and also brought changes with respect to recognizing the right of inheritance of Hindu females at par with the males. Under the Section 6 of the Hindu Succession Act, it was provided that whenever a male Hindu having an interest in a Mitakshar co-parcenary property died after the commencement of the Act, then his interest in the property would devolve by rule of survivorship and not in accordance with the Act. However, proviso to Section 6 incorporates that when Mitakshar co-partner died leaving behind a female heir of class 1 or a male heir claiming through her, then the interest would devolve by testamentary or intestate succession in accordance with the Act and not by the rule of survivorship. Therefore, it is evident from the Act that Hindu females would not inherit ancestral property by birth and were excluded from the joint family co-parcenary under the Mitakshar system. If the joint family property was divided, then each male co-partner took his share and females got nothing. Only when one of the co-partners died did Hindu females get a share in the interest as an heir to the deceased co-partner. There were several disadvantages under the Hindu Succession Act of 1956 for the females. Even though females got a share in the interest as an heir to the deceased co-partner only when the co-partner died under the Section 6, and they did not get any share when the joint family property was divided. Under Section 4, subsection 2, women had unequal position with respect to inheritance in agricultural land. Under Section 23, female heirs were disentitled from asking for partition of a dwelling house occupied by a joint family. Under Section 24, certain widows like a predeceased son's widow or the widow of a predeceased son of a predeceased son or the widow of a brother in succeeding to the property of the intestate on the remarriage during the lifetime of the intestate. Under Section 14, subsection 1 of the Act, it says that any property possessed by a female Hindu, whether acquired before or after the commencement of the Act, shall be held by her as a full owner and not as a limited owner. Further, through the explanation appended to the subsection 1 of Section 14, different methods by which the woman may have acquired property are enumerated or would have acquired property, and states that property includes both movable and immovable property acquired by the Hindu female by inheritance, devise, or at a partition, or in lieu of maintenance or arrears of maintenance, or by gift from any person, whether relative or not, before, at, or after her marriage, or by her own skills or exertion, or by purchase or by prescription, or in any other manner whatsoever. And all such properties which were held by her as Stridhan, all of these properties would be held by her as a full owner and not as a limited owner. The objective of the Section 14 is twofold. Firstly, it is to remove the disability of the female to acquire and to hold property as an absolute owner, and secondly, to convert any estate which is already held by the woman on the date of the commencement of the Act as a limited owner to an absolute estate. However, where a female Hindu after the commencement of the Act is given any property with certain limitations, she would hold that property which is subject to those limitations and cannot acquire these properties as an absolute owner. These limitations are set out in the subsection 2 of section 14, which runs as follows. Nothing contained in subsection 1 shall apply to any property acquired by way of gift or under a will or any other instrument under a decree or order of a civil court or under an award where the terms of gift, will or other instrument or decree, order or award prescribe a restricted estate in such property. Section 14 subsection 2 is an exception to section 14 subsection 1 and it enacts a well-established principle of law that if a grant is given subject to certain restrictions, the grantee will take the grant subject to those restrictions. Thus, in the absence of any provision in the will, gift, decree, order of civil court, award or any other instrument prescribing any restricted estate on a Hindu female, she would take it as an absolute estate. Section 14 subsection 2 applies to instruments, gifts, decrees, awards, etc., which create an independent right or a new title in favor of the Hindu female for the first time and not in recognition of pre-existing rights. The general rules of succession to the property of a Hindu female dying intestate have been given in section 15 and section 16. Section 15 subsection 1 provides that if a Hindu female dies intestate, then her property shall devolve according to the rules set out in section 16. Firstly, upon the sons and the daughters of the Hindu female and the husband. Secondly, upon the heirs of the husband. Thirdly, upon the mother and the father of the female. And fourthly, upon the heirs of the father. And lastly, upon the heirs of the mother. However, if a female Hindu dies issueless, leaving behind no child or grandchild, then different rules will govern the matter of succession to her property, depending on whether she has inherited the property from her father or mother or from her husband or father-in-law. Section 15 does not apply to the property held by a Hindu female with restricted rights, that is provided in section 14 subsection 2 at the time of her death, but applies to cases where she becomes a fresh stock of descent. Under subsection 2a of section 15, if a Hindu female inherits any property from her father or mother and she dies without children or grandchildren, then her property devolves on her heirs of her father. There were several state amendments brought to the succession laws in order to remove the inequalities between men and women in matters of property rights. Certain states like Kerala, Andhra Pradesh, Tamil Nadu, Maharashtra and Karnataka realized that for economic and social justice to prevail, women must be treated equally. Accordingly, the Kerala Joint Hindu Family System Abolition Act of 1975 completely and fully abolished males' right by birth to property and brought an end to the Hindu joint family system. In the 174th report of the Law Commission of India on property rights of women, proposed reforms under the Hindu law, it was said that discrimination against women is so pervasive that it sometimes surfaces on a bare perusal of the law made by the legislature itself. It is particularly so in relation to the laws governing inheritance and succession of property among the members of the Hindu joint family. It seems that this discrimination is so deep and systematic that it has placed women at the receiving end. In consonance with the recommendations of the report of the Law Commission, the Hindu Succession Act of 2005 was brought in. The Hindu Succession Amendment Act of 2005 bettered the daughter's position by amending the Section 6, which deals with the devolution of interest in the co-partnery property. Section 6, subsection 1 provides that the daughter of a co-partner in a joint family governed by Mitakshar law shall, on and from the commencement of the Hindu Succession Amendment Act of 2005, by birth become a co-partner in her own right and in the same manner as the son. So we find that with the commencement of the Hindu Succession Act of 2005, the Section 6 was amended and daughters were made co-partners in the same right as the sons. The Hindu Succession Amendment Act of 2005 also said that the daughters shall have the same rights and be subjected to the same liabilities in the co-partnery property as that of a son. This provision applied to both married and unmarried daughters before the commencement of the Amendment Act of 2005. Any disposition or alienation, including partition or testamentary disposition of property which had already taken place before 20th of December 2004, shall not be affected or invalidated by the provisions given in Section 6, subsection 1. Section 23 of the Hindu Succession Act was omitted by the Amendment Act of 2005, and now daughters, whether they were married or unmarried, were entitled to the same rights as the sons to reside and claim partition of the parental dwelling home. Section 24 has also been omitted. This section earlier disqualified certain widows on remarriage from succeeding to the property of the intestate. These widows were the widow of a predeceased son, or the widow of a predeceased son of a predeceased son, or the widow of the brother, and they can now inherit the intestate's property even if they have remarried. Also, the Amendment Act of 2005 has added heirs to the list of Class 1 heirs, such as the daughter's daughter's daughter, the daughter's son's daughter, the son's daughter's daughter, and the daughter's daughter's son. To conclude, it can be said that the position of the Hindu woman in respect of her property rights has undergone unprecedented transformation. Hindu daughters' property rights have been recognized, but non-inclusion of other Hindu females is unjust. As we have seen, under Section 6 of the Hindu Succession Act, the daughters have been made co-partners, but the other Hindu females do not find any place in the co-partnery. So, it can be said that despite the changes brought by the Hindu Succession Amendment Act of 2005, females are often denied their rights in our patriarchal society, and many times they fail to claim their rights in the joint family properties. Thank you.